Bharat has broken the shackles of colonialism. A date immortalized in India's democratic journey. India's criminal justice system witnesses biggest reform as Parliament of India passes 3 key bills.
Those in favor will please say aye. Those against will please say no. I think the ayes have it. The ayes have it. The ayes have it. The bill is passed.
Prime Minister Narendra Modi lauds the passage of Bharatiya Nagrik Suraksha Sanhita, Bharatiya Nyay Sanhita and Bharatiya Sakshya Adhiniyam by Parliament and calls it a historic moment in India's history. He underlines that these bills ensure enhanced protection for poor, marginalized and vulnerable sections of the society, while also coming down heavily on organized crime, terrorism and other such offences. Changes have been made in the 3 laws governing nearly 150 years old criminal justice system, Indianness, Indian Constitution and People of India.
इतिहास है बोलकर भूल जाना हमारा इतिहास है, जो मोदी जी कहते हैं वो करते हैं। मैं आशा करता हूं कि ये भारत की क्रिमिनल जस्टिस सिस्टम में एक नए युग की शुरुआत होगी, जो पूर्णतया आपराधिक कानून और आपराधिक प्रक्रिया हमारे कंकरन लिस्ट में है, परंतु कई सालों से आईपीसी 163 साल से, सीआरपीसी 125 साल से और एविडेंस एक्ट 150 साल से जो ब्रिटिश पार्लियामेंट ने बनाए थे, वही एक्ट को आज हम उसी एक्ट से आज हम गवर्न हो रहे हैं। नरेंद्र मोदी जी ने आजादी के 75 साल बाद इस देश में सारे कॉलोनियल कानूनों के अंदर उसको बदलाव कर समाप्त कर भारत की आत्मा को प्रस्तावित करने की शुरुआत। इसका पूरा इम्प्लीमेंटेशन हो जाएगा, तब एफआईआर से लेकर जजमेंट तक की पूरी प्रक्रिया ऑनलाइन हो जाएगी और टेक्निक का सबसे ज्यादा उपयोग अगर कोई एक देश की क्रिमिनल जस्टिस सिस्टम के अंदर होगा तो वो भारत की क्रिमिनल जस्टिस सिस्टम। भाषा को आगे बढ़ाए वो स्वराज है, स्व संस्कृति को आगे बढ़ाए वो स्वराज है, और वो स्व शासन को जो प्रस्तावित करे वो स्वराज है। लोकतंत्र में बैलेंस ऑफ वर्क की एक टर्म्स को बहुत महत्व दिया जाता है। आपराधिक न्याय प्रणाली जो अभी हमारे देश के अंदर काम कर रही है, उसमें ये बैलेंस बिगड़ गया और हमने इसके अंदर बैलेंस ऑफ वर्क का बहुत बारीकी से ध्यान रखा। कानून का संपूर्ण इम्प्लीमेंटेशन होने के बाद तारीख पे तारीख का जमाना जाएगा। 3 साल में किसी भी विक्टिम को न्याय मिल जाए, ऐसी न्याय प्रणाली इस देश के अंदर प्रस्तावित होगी। क्या होगा इस कानून से? आजादी के 75 साल तक और 4 दशक से आतंकवाद का दंश झेलने के बाद इस देश की आपराधिक न्याय प्रणाली के कानूनों के अंदर आतंकवाद की डेफिनेशन नहीं थी। नरेंद्र मोदी जी ने जीरो टॉलरेंस टुवर्ड आतंकवाद का परिचय कराते हुए टेररिज्म की डेफिनेशन को इसके अंदर शामिल किया है। मान्यवर जो पूछते हैं कि इस कानून से क्या होगा, मैं उनको बताना चाहता हूं कि इस कानून से राज्यद्रोह अब देशद्रोह के अंदर बदल गया है।
Namaskar, hello and welcome viewers. You're watching this special presentation of Sansad TV with your host Kriti Mishra. India's criminal justice system is set for a complete overhaul. Parliament of India has passed 3 key bills to replace colonial era codes with the objective of speeding up trials by laying down specific timelines, boosting rates of conviction by improving the quality of evidence and providing relief and protection to victims. In the old laws, instead of giving priority to homicide and misbehavior with women, priority was given to the protection of treasury, protection of railways, and the safety of the British Crown. A new era begins with the laws centered on public service and welfare. So what are the key provisions of these path-breaking legislations? How will they impact you? And much more in this edition. Come along. India's criminal justice system has been predominantly shaped by laws and regulations inherited from the British colonial era. In the post-independence years, these legal foundations underwent alterations and amendments to align with the evolving requirements of modern times. The experience of 7 decades of Indian democracy calls for comprehensive review of our criminal laws, including the Code of Criminal Procedure, and adopt them in accordance with the contemporary needs and aspirations of the people of India. The pre-independence criminal laws were used by the British to protect their colonial interests, to rule the people and the country, and to maintain their authority and supremacy over India. There was a need for comprehensive review of the criminal laws, especially the Indian Penal Code, Criminal Procedure Code, and the Indian Evidence Act, and adapt them according to the present-day needs and aspirations. In 2019, Prime Minister of India advocated for the need to revamp all the legislations enacted across all departments during the British era.
देश ने 1,500 से ज्यादा पुराने और अप्रासंगिक कानूनों को रद्द कर दिया है। इनमें से अनेक कानून तो गुलामी के समय से चले आ रहे हैं।
In accordance with the basic principles enshrined in the Constitution of India, it was proposed to bring about fundamental comprehensive changes in the framework of Indian criminal laws. With this objective, the existing Indian Penal Code 1860, the Code of Criminal Procedure 1973, and the Indian Evidence Act of 1872 is now repealed and replaced by Bharatiya Nyaya Sanhita 2023, Bharatiya Nagrik Suraksha Sanhita 2023, and the Bharatiya Sakshi Bill 2023, respectively. The main problems in present legal system are complex in nature. There is huge pendency of cases in the courts, there is low conviction rate, and the amount of fine prescribed in the laws is very less, from 10 rupees to 500 rupees. There is also overcrowding of under-trial prisoners in prisons. There is very little use of modern technology in the legal system. There is also delay in investigation and delayed justice due to inadequate use of forensic evidence.
गरीब आदमी के लिए न्याय महंगा नहीं। टेक्नोलॉजी का उपयोग कर और पुलिस, वकील और कोर्ट तीनों को लिए समय मर्यादा बनाकर हमने जल्दी न्याय की प्रक्रिया को आगे बढ़ा है। अब तारीख पे तारीख नहीं होगी, 3 साल के अंदर फैसला हाथ में। जो कहते हैं क्या हुआ है, कई बार भ्रष्टाचार से कोई जजमेंट इधर उधर आ जाता है, गलती से आता है। इसकी अपील का निर्णय कौन करता है माननीय महाराज? अपील जिसने प्रोसिक्यूशन का जो वकील है वो ही करता है। हमने इसमें डायरेक्टर ऑफ प्रोसिक्यूशन के अस्तित्व को कंपलसरी कर दिया है, जो पहले एडवाइजर था, और हर जिले में एक डायरेक्टर प्रोसिक्यूशन रहेगा जो पूरी प्रोसिक्यूशन की प्रक्रिया से अलग रहकर ये अपील योग्य केस है या नहीं है इसका निर्णय करेगा। इससे सबको मालूम पड़ेगा।
These new bills seek to holistically address the problems in the criminal justice system to strengthen law and order, simplifying legal procedure, providing speedy justice, and to adapt the criminal justice system with the technological advancements. Further, all the outdated references have been deleted in these bills. All the provisions have been made in the laws to equip our judicial system by imagining the possible technological innovations that may take place in the coming 100 years. A good balance has been maintained between the rights of the people and the citizens. Provisions have been made in these laws to increase the rate of punishment and to prevent cyber crimes. To reduce the burden on jails, community service is also being included as a punishment for the first time and is being given legal status.
जो कह रहे हैं इससे क्या होगा, मैं इनको कहना चाहता हूँ, ब्रिटिश संसद ने बनाए हुए कानूनों को समाप्त कर मोदी जी ने भारतीय संसद की गौरव को बढ़ाया है। आज पूरा देश ये कानून पारित होने के बाद हमारी संसद के बनाए हुए कानून के खिलाफ।
In Bharatiya Nyaya Sanhita, priority has been given to crimes related to humans like rape, gang rape, crime against children, murder, kidnapping and trafficking. The government has also taken a historic decision and completely removed the section of sedition. Sedition has been replaced with treason. Home Minister has said that no one can speak against India and no one can harm its interests. He has also said that if anyone plays with the flag, borders and resources of India, he or she will definitely have to go to jail, because the government's thrust is that the security of the country comes first.
भारतीय न्याय संहिता ने भी सुरक्षा संहिता में 9 नए सेक्शन, 39 नए सब सेक्शन जोड़े हैं, 44 नए स्पष्टीकरण और व्याख्याएं जोड़ी है, 35 सेक्शन में टाइमलाइन डाली है और 14 धाराओं को हमने निरस्त किया है.
A total of 3,200 suggestions were received regarding these laws, and the Home Minister himself held 158 meetings to consider these 3 laws. On August 11, 2023, these bills were sent to the Standing Committee of Parliament on Home Affairs.
This is 75th year of our independence. Now, the salient features. The Bharatiya Nyaya Sanhita, number of sections have been reduced from 511 to 356, and the chapters from 23 to 90. This is regarding Bharatiya Nyaya Sanhita, that is old Indian Penal Code. We have used the word Nyaya, not a dand, not a penal, because this is a democracy. We are giving justice, not dand, not a penalty. 24 sections have been deleted from old Indian Penal Code, 22 have been added, and a large number of sections have been rearranged.
Parliament also saw rich debate on these key bills as members made meaningful submissions.
ये देश हमेशा ऋणी रहेगा. जो 150 वर्ष के दास्ता के प्रतीक जो कानून है उनको खत्म करने के लिए माननीय प्रधानमंत्री जी का और माननीय गृह मंत्री जी का.
The bill also looks at Rashtriya Suraksha. For the first time, we have a general statute which defines terrorism and makes it punishable.
The Law Commission of India, in its various reports, recommended several amendments in the criminal laws. Let's take a look at the key provisions of these 3 bills. The Bharatiya Nyaya Sanhita 2023 repeals the Indian Penal Code. Key changes proposed in the bill include: IPC defines sedition as bringing or attempting to bring hatred or contempt or exciting disaffection towards the government. It is punishable with imprisonment term between 3 years and life imprisonment and or a fine. The bill removes this offence. It instead penalizes exciting or attempting to excite secession, armed rebellion or subversive activities, encouraging feelings of separatist activities, or endangering sovereignty or unity and integrity of India. These offences may involve exchange of words or signs, electronic communication or use of financial means. Terrorism. The bill defines terrorism as an act that intends to threaten the unity, integrity and security of the country, to intimidate the general public or disturb public order. The bill also penalizes conspiring, organizing or assisting in preparation of any terrorist act with an imprisonment term between 5 years and life imprisonment and a fine of at least 5 lakh rupees. Petty organized crime. The bill makes attempting or committing petty organized crime punishable with imprisonment between 1 and 7 years and a fine. Death penalty for gang rape of minor. IPC allows death penalty for gang rape of women below 12 years of age. The bill now allows death penalty for gang rape of women below 18 years of age. The Bharatiya Nagrik Suraksha Sanhita 2023 was introduced in the Lok Sabha on 11th of August 2023. It repeals the Code of Criminal Procedure 1973. The code provides for the procedure of arrest, prosecution and bail for offences under various acts including the Indian Penal Code 1860. The key provisions now include trials in electronic mode. The bill provides that all trials, inquiries and proceedings may be held in electronic mode. It also provides for the production of electronic communication devices likely to contain digital evidence for investigation, inquiry or trial. Electronic communication includes communication through devices such as mobiles, computers or telephone. Forensic investigation. The bill mandates forensic investigation for offences punishable with at least 7 years of imprisonment. Timelines for procedures. The bill prescribes timelines for various procedures. For instance, it requires medical practitioners who examine rape victims to submit their reports to the investigating officer within 7 days. Trial in absence of offender. The bill provides for conduct of trial and pronouncement of judgment in the absence of a proclaimed offender. This shall be done when such a person has absconded to evade trial and there is no immediate prospect of arresting him. The Bharatiya Saksha Adhiniyam 2023 was introduced in the Lok Sabha on 11th of August 2023. It repeals the Indian Evidence Act of 1872. The Act provides rules for admissibility of evidence in legal proceedings. Admissibility of electronic or digital records as evidence. The bill provides that electronic or digital records will have the same legal effect as paper records. It expands electronic records to include information stored in semiconductor memory or any communication device. Oral evidence. Under the Act, oral evidence includes statements made before courts by witnesses in relation to a fact under inquiry. The bill adds any information given electronically to be considered as oral evidence. Secondary evidence. The bill expands secondary evidence to include oral and written admissions and the testimony of a person who has examined the document and is skilled in the examination of documents. These proposed legislations, being brought in place of 3 old laws, have been made on the basis of 3 basic spirits of our Constitution: freedom of the individual, human rights, and the principle of equal treatment to all. The purpose of giving punishment is to give justice to the victim and to set an example in the society so that no one else commits such a mistake. These 3 new laws are being humanized for the first time after so many years of independence. These transformative bills are a testament to India's commitment to reform. They bring our legal, policing, and investigative systems into the modern era with a focus on technology and forensic science. These bills ensure enhanced protection for the poor, marginalized, and vulnerable sections of our society. Well, viewers, with that, it's a wrap from my side. Thanks for watching and stay tuned to Sansad TV. Goodbye for now from my side.